Okay. Looks
Cool.
like we're rolling. Sorry for the delay, folks. Just had a minor technical glitch. Um, yeah, welcome to the American Prospect weekly roundup where we, discuss whatever's on our minds over the past week. And I'm Brian Cooper. I'm the Prospect's managing editor, and I'm pleased to welcome Prospect alumnus, I believe, Jamelle Bouie, who is now a New York Times opinion columnist and co-host of the Unclear and Present Danger podcast with John Gans, which is very good. Welcome to the show, Jamel.
Thank you for having me, Ryan.
I am not surprised to see that your streaming setup is much more sophisticated and nice looking than mine. Horribly cluttered office and bad clothing. But, we have to live our truth. Um, Anyway, so I wanted to have you on, to discuss the Supreme Court and a few of the recent decisions that have come out. Some real bangers coming from the conservatives there. And I thought we could start with the new Sam Alito heater uh, in the case Alexander versus South Carolina State Conference of the NAACP. Um, this case is about just flagrant racial gerrymandering in South
Right.
Carolina. And Sam Alito says, it's great. It's great we do it. We can just go hog wild, more or less. Maybe not as much as Clarence Thomas, but we'll get to his concurrence in a minute. Little bit of background. Um, that the previous most recent case I believe relating to this is Rucho versus Common Cause from 2019.
That's right.
And that said, that federal courts have no power over partisan gerrymandering. Um, but it did say that it's bad and sort of an affront to democracy, just that, they couldn't do anything about it. Sorry, hands tied, folks. And that was a change from precedent because they used to at least suggest that this could be, a violation of people's civil rights. Um, and Cooper versus Harris from 2017, which said that racial gerrymandering is, against the Constitution. Um, and so, yeah, could you, basically explain the sort of, what South Carolina was doing and, the reasoning in the Alito opinion as you see it?
Sure thing. So the South Carolina legislature had created a federal congressional map that had racially gerrymandered, or the lower court found had racially gerrymandered black voters out of a district. So to make the district more secure for the for the Republican candidate, the South Carolina legislature had removed black voters from it, knowing that in much of the South, there's pretty much like a one-to-one correlation between like race and partisanship. If you are white, you're most likely to be a Republican. If you're black, you're most likely to be a Democrat. Um, a lower court, and this is a really key thing. The district court here, in its factual findings, found that the South Carolina legislature had done an unconstitutional racial gerrymander, and so they said this map has to be redrawn. You have to redraw this map to account for this for the gerrymander. This case makes South Carolina appeals. The case makes its way up to the Supreme Court, and in its decision, 6-3 decision written by Alito, Alito essentially says that, I mean, first Alito disregards the factual finding completely, and instead states that uh, the lower courts were not giving basically a good faith understanding, the presumption of good faith to the South Carolina legislature in its districting, and is making the argument as well that generally courts really shouldn't be involved in districting. This is a responsibility. This is the thing that belongs to the states. Um, and so, how do I put this? And so Alito's position and the position of the majority is that because the lower court is kind of encroaching on the territory of the state legislature, and also because it's not extending the presumption of good faith, because it is making grave accusations against the legislature. This is what Alito wrote. When a federal court finds that race drove a legislature's redistricting decisions, it is declaring that the legislature engaged in offensive and demeaning conduct that bears an uncomfortable resemblance to political apartheid. We should not be quick to hurl such accusations at the political branches. Um, Alito concludes that this really isn't any of the business of the lower court to begin with. We have to extend charity to the legislature, and they let the map stand. So the reasoning here, I mean, Alito isn't so much, how do I put this? Alito isn't directly saying racial gerrymandering is all right. He's saying that there's plausible explanation. This is partisan gerrymandering. Partisan gerrymandering is a thing that legislatures can do, and in any case, it's not really any of our business to levy these sorts of accusations at a legislature. It's in Thomas's concurrence, Clarence Thomas, that Clarence Thomas just full on says racial gerrymandering is fine.
Yeah. Yeah, I want to get to that one in a minute, but yeah, I think important to emphasize, I failed to mention earlier that, whereas the previous case in Rucho had at least sort of flicked at, partisan gerrymandering being like an obvious, like you're cheating the election, you're cheating the electoral process to win, by default. And now Alito says, you know, quote, as far as the federal constitution is concerned, a legislature may pursue partisan ends when it engages in redistricting. And, I mean, you don't have to open a history book to see, the potential problems with this. In Wisconsin, for instance, in the 2018 election, I believe that the Democrats won the popular vote by 8 points, and Republicans still got like almost a two-thirds supermajority in the legislature, the assembly, that is, the lower house.
Right. This even if you set aside the racial gerrymandering thing for a second, and just like this stance on partisan gerrymandering comes very close to undermining the principle of one person, one vote, as expressed in Baker v. Carr and Reynolds v. Sims. This notion, prior to the 1960s, basically, for viewers who aren't aware of this, there was actually no federal or constitutional standard for how many people had to belong in a state legislative or state any kind of sub-federal district, right? So I live in Virginia. It was entirely legal in the 1950s and 1940s to draw the districts in Virginia such that maybe one set of lawmakers only had to represent 1,000 people, and then another set had to represent 100,000 people. Like you could draw these unequal districts, and the purpose of doing so was very explicitly to weight power in the hands of white, rural, generally understood to be more conservative residents over those in urban centers. And accordingly, state level policy, and by extension, federal level policy, because the states were also doing districting for federal districts, was very much tilted against the interest of people who live in cities, against the interest of immigrants, racial minorities, et cetera, et cetera. And the court in the 60s says you can't do that. Like it's a violation of the Equal Protection Clause of the 14th Amendment. And that kind of is like opens the door for a lot, just a wave of democratization, right? Along with the Voting Rights Act a few years later, there's a sudden wave of democratization throughout the country as suddenly elections are competitive again, or competitive for the first time in some places. And it's clear to me, at least, that the current court's sort of acceptance of partisan gerrymandering, of extreme forms of partisan gerrymandering, is basically sort of like a backdoor way to push against that, to push against the notion that there's a responsibility on part of the courts to ensure that elections are competitive, that there's actually meaningful democracy and meaningful electoral choice versus the formal electoral choice.
Yeah. Yeah. And I mean, maybe just worth drawing out. explicitly, it's like, why do we have a vote? The vote is supposed to have an influence on who governs you. The political power comes from the consent of the governed. And when you just rig up the system so that your party can't lose,
Right, right,
that's not democracy anymore. That's an
right.
authoritarian system. Um, the other thing to mention about this, I think, is that it reveals the sort of two-step that these frauds on the court are constantly engaged in when it comes to the question of, like, quote unquote judicial power, and the proper role of legislatures and so on, because they say that, oh no, we can't be involved in this. This is a thing that for the politicians to figure out, not us. We can't be involved in this, even though Congress has said, in the Civil Rights Act, I believe, that there is a legal right, like you can legally access the courts if someone violates your civil rights, including the right to vote. And as you mentioned before, Baker versus Carr, the Supreme Court itself also held that to be true. It was a judicial, how do you say that? Um,
Judiciable.
Judiciable. Yeah, excuse me. I haven't had enough coffee yet. And yet, when the Congress passes the Voting Rights Act that says, for example, you states in the South with a history of, being a one-party dictatorship, so to speak, you have to go through certain requirements so that we know at the federal level you're not disenfranchising your black population. The Supreme Court in Shelby versus Holder says, no, you can't do that. We're going to stop you from doing that. So it's like, whenever, it's just a purely oppose, I guess, is what I'm getting at. And you really
Right.
see these people don't believe in judicial restraint in the slightest. They believe in judicial supremacy, that the court gets to rule by decree, and that, anybody else will just come up with something for you. Regardless. Uh, so I guess before we get to Clarence Thomas, because boy, he's a whopper of a decision, or a concurrence rather. Um, I was curious as to your thoughts about how we should think about, judicial power in this, context. And I'm quite skeptical of judicial review in general as a sort of like theoretical matter, but there's a long history that people have basically forgotten entirely, uh, where judicial review is much more contested. The idea that the court is the only party that gets to um, interpret the Constitution, as opposed to one, the president, maybe also, and Congress especially, also gets the ability to influence that decision. So what are your thoughts about how we should sort of think about this? How should we conceptualize judicial review and the power of the courts in the context of this totally rogue majority?
Yeah, it's interesting. So, I guess first a little history. Judicial review as an idea, the idea that courts have this ability to basically harmonize legislation with higher law, with constitutions of some sort, is not it's not a modern idea, right? It's present in Anglo-American jurisprudence, like before the Revolution. And you see sort of like the pieces of it like, taking shape throughout the colonial era, especially in the 1740s, 1750s, 1760s. It's sort of part of how people understood the role of courts. And when the Constitution is constructed in 1787, ratified in 1788, you'll notice in the ratification arguments, sort of Alexander Hamilton, the Federalist Papers, like other framers are essentially making the argument that judicial review is going to exist, right? It's almost implicit. They consider it almost implicit in the notion of a Supreme Court and a constitution, right? If we have this document that represents kind of the not just the structure of the government, but the higher law, there has to be some mechanism by which we align ordinary legislation passed with that higher law. And that mechanism is the highest court, the Supreme Court, and it's going to do it through judicial review. Now, having said that, how judicial review develops, the forms it takes, that's of course highly contingent. And so, most famously, John Marshall in Marbury v. Madison, uh, kind of affirms this view, first of all, that, yeah, the Supreme Court is the place where we say what the Constitution means. A quick parenthetical, Marshall doesn't say the Supreme Court is exclusively the institution that makes constitutional meaning, but is saying that in practice, practically speaking, this is where this is where we're gonna hash out these questions in terms of like, is this law something we're allowed to do? Um, and I believe it's in McCulloch v. Maryland, where Marshall kind of like builds upon this, and explains that, like, their judicial review also kind of includes the power to um, overturn congressionally enacted statutes, kind of reaffirming this notion that, like, this is where all this happens. Now, the court does not overturn a congressional law uh, again until Dred Scott v. Sanford in 1857. So, like, even though this power is claimed, and even though it's exercised quite a bit with regards to state laws, the Supreme Court really is going after state laws a lot, kind of trying to create kind of a unified national community that's part of like the project of the Marshall Court. Uh, it's not really going after congressional stuff. It's only with Dred Scott that we see the court overturn a duly passed and signed act of Congress. And that becomes massively controversial, right? Because it's in Dred Scott that the court is making kind of its first kind of claims towards judicial supremacy, which I think we should distinguish from judicial review, or this notion that the court has this role in interpreting the Constitution. Judicial review doesn't preclude the idea, as you said, Ryan, that other constitutional actors, including the public, which should be understood as the constitutional actor, have an understanding of the Constitution that ought to weigh on how its representatives and such act. With Dred Scott, the court is saying none of that matters. What we say is what it means, and that prompts like this huge backlash. And Lincoln, of course, in his first inaugural, like nods to that backlash when he basically says, "Listen, you know, if this is the case, then this isn't really a representative government. Like, we all have a role in understanding the Constitution." And Lincoln is this great advocate for kind of popular constitutionalism. I'm not going to go through the entire Supreme Court. I'll just fast forward to say that the relationship between the public, lawmakers, and the court and the understanding of the Constitution is sort of like contingent and flows back and forth over the years. As we get further deeper into the 19th century, the court kind of takes precedence. You can look at kind of the New Deal era as a period of time where it's the elected branches and the public that is like pressing against the court and saying, "Listen, your understanding of what the Constitution allows is too limited and restricted." After the Second World War, this interesting thing happens where, in an attempt to kind of like settle in this against the backdrop of the Cold War, settle kind of like key social disputes, political disputes, and everything, elected officials basically begin deferring to the court more and more and more. Also, the court is taking this greater role as it's becoming the venue for assaults on Jim Crow and so on and so forth, since there isn't really a political option available for those activists and those thinkers. And it's really only in the last 40 or 50 years that we've seen this notion of the court develop, where it's not just one constitutional actor among many, but sort of like the only place where constitutional meaning can be determined. And that's, I think, what we should label judicial supremacy. In my view, is that like that's absurd. It's like a ridiculous conceit to say that these 9 people are the only ones who have the training or wherewithal or understanding to say what the Constitution means. And I think it's worth saying that, like, this notion of the Supreme Court having exclusive command over the meaning of the Constitution is happening in tandem with the elitification of the Supreme Court. Prior basically to the 1970s, it was quite common to have politicians, to have lawmakers or legislatures, former lawmakers, legislatures, a former president, Basically, they have people who did not have who had legal training but not elite legal training, did not spend their lives in legal academia, did not spend their lives on courts to occupy a spot in the Supreme Court for the simple reason that the court was understood to be this political institution and part of the larger political system. But really, since the 1980s, what we've been seeing, right, are justices appointed to the court whose primary background is in the elite reaches of law. Um, and I don't think it's an accident. I don't think it's like a coincidence that this notion of judicial supremacy happens in tandem with the elitification of the court, and also the emergence of originalism as a set of ideas and doctrine, which is all about this sort of like esoteric exegesis of constitutional texts, as if these things were written to be exclusively understood by priests and not lay documents for the broader public to be able to dissect and offer their own understanding.
Yeah, the other thing I think to mention about that is the way that the ability of Supreme Court justices to choose when they retire massively decreases the accountability of the court itself, because you can, absent accident, effectively pick your successor if you time it right,
Right.
uh, and you don't, you know, like Ruth Bader Ginsburg, attempt to hold on, after you've already gotten a like 99% fatal cancer diagnosis, but that's water under the bridge. But basically, we have six people on the court, and all they have to do is hang on until there's another Republican president, which surely will happen within the next 20 years, highly likely. Um,
The
Democrats
other
have,
thing I'll add, in terms of accountability, is that it used to be that the court in the 19th century, the court could not choose which cases it took. It just
yeah,
it just had whatever mate came its way, it had to sort of adjudicate. Um, and it's only beginning, I believe, in the 1920s that the court was given the power basically to choose what it wanted to handle. And that itself is a tremendous amount of power, right? If you can
yep,
choose which disputes you are going to tackle, then you have a huge amount of influence, especially if you're no longer bound by precedent, right? If you're no longer bound by precedent, if you're no longer bound by anything other than your own sense of what the Constitution means, and you can choose your cases. And as we're seeing most recently, you can kind of just like ignore questions of standing, right? You can ignore sort of whether or not this person even has a real dispute that can be adjudicated. Um, then you kind of have unlimited power. There's,
yeah,
there's not really any mechanism to hold you accountable at that point.
yeah, true. Yeah, and as I like to, again, to emphasize, like what one reason, and we'll get into this topic later, that we really need to reckon with questions like court reform, is that it's highly plausible to think that liberals will not ever again get a majority on the court. So long as you just need to hold on for 20 years or so, and here comes another Republican president, and then you just replace the old guys with Heritage Foundation interns decanted out of the cloning tank or whatever. And then you got another, 30, 40 years. Um, anyway, yeah. So let's talk about Clarence Thomas, our favorite justice. We all know him. We all love him. And he had a concurrence to the Alito opinion, which was shockingly even crazier than the Alito one, dramatically crazier, I think I would say. And he basically comes out swinging against Brown versus Board of Education. And so can you get into the substance of that decision, and what just what he is talking about?
So Thomas does not believe that the courts have such a broad ability to create remedies. Thomas believes that the federal court's ability um, to remedy, claims about voting discrimination or racial discrimination is very, 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 very limited. Basically, sort of like limited exclusively to like the dispute in question, if even that. And so in his concurrence, Thomas is basically saying, listen, not only do I agree with my colleague, Justice Alito, about the fact that partisan gerrymandering doesn't have anything to do with us, I'm also not I also not sure that racial gerrymandering, we have anything to do with racial gerrymandering, because it's beyond the scope of courts to even deal with these questions. It's beyond the scope of courts to provide remedies for that. Courts in 1787, 1788, they weren't map makers, and so courts are not now. As a parenthetical, it's sort of like this static conception of what courts are and can be presupposes that the Constitution never changed after it was ratified, or that subsequent amendments don't reflect back on the meaning of the original document. Um, I'll mention here there's a great book called The Second Creation by historian Jonathan Gnapp, I believe is how you say his last name, that is about kind of like, what you could call like the fixing of the Constitution after its ratification, after it comes into effect, meaning we have this document. Now, what is it actually? What is it really? And how does it play out in practice? And one of the early debates about the Constitution was like, how actually are we going to amend it? Not in terms of like the process, but you pass an amendment. Does that amendment get incorporated into the text itself, or is it appended to the text? And one of the arguments for incorporating it into the text itself was that it would make clear that amendments do affect the original text, that they aren't just something like tacked on. Um, and everyone decided, not everyone, but it was decided that like it was just kind of a little easier to append them, that we didn't want to, like, already very early on you're seeing kind of like the sanctification of the Constitution. We don't want to alter this sacred text, and so we'll just do append the amendments. But I think they're like real kind of consequences for how we conceive of the Constitution when the amendments were kind of appended. They seem tacked on rather than incorporated. Anyway, that's a bit of a digression. It's just interesting thing to think about.
Yeah.
Um, uh, but Thomas is like, courts can't do this. And Brown v. Board of Education may have represented some of this overreach in the kinds of remedies that courts produce. Yeah. We wanted to do something about racial justice, but do courts really have the power to offer these sort of remedies, touch these sorts of concerns in the society? And I believe I said this on the social network Blue Sky, but this is suspiciously similar, basically, to the majority reasoning in Plessy v. Ferguson, which, as you know, when you learn Plessy, you learn it as separate but equal is legal. But the actual sort of argument of Plessy, of the majority decision, was that although the 14th and 15th Amendments were written to prevent discrimination against Black people, they have no bearing on existing social equalities in the society. The Constitution does not see them or recognize them and cannot touch them. And so if you come to the courts saying, oh, this is a legal discrimination against me on the basis of my race by this private entity or by the states even, the only thing federal courts can say is, well, that's not really our problem. And as long as it isn't, there's no explicit law saying that Black people must do this and white people must do this, then, our hands are tied. And that's kind of, it's basically Clarence Thomas's position.
Yeah. The I think, a brief tangent. My favorite part of the opinion was in part of the argument, he says basically that courts shouldn't have this power to draw maps um, because they only get the powers claimed by, quote, the High Court of Chancery in England at the time of the adoption of the Constitution. And I mean, your mind just reels.
Right.
They've done this before, referencing stuff, in England in like the 1500s or whatever. But you're just like, what are you talking about, dude? Like,
Right,
it's
right.
a different country. We had a whole revolution and everything, and then we wrote down new laws. Like they evolved out of the English ones, but they're not. You're just I don't know. It's just like a new sort of like thing they've decided to say. It's like, here's some words we could put down, but boy, that is just a crazy one.
You know, as I think about it, what makes it especially crazy is that it really is a statement that what the public believes to be true about the Constitution just doesn't matter, right? Like you ask a random person, "Hey, are we bound by the rules of 18th century English courts? And they would say, what the fuck are you talking about? Right? Like, of course not. Um, and I would say, right, that this deep-seated understanding that, of course, we are not bound by the rules of 18th century courts or 17th century legal thinkers ought to be given its due constitutional weight. It matters, right, for the legitimacy of the courts, for the legitimacy of their decisions, for what the Constitution is. And the view of Thomas and of Alito and of Gorsuch, right, is that like, no, no, no. If I can find some obscure bits of text, then those outweigh any popular conception of what the Constitution is. And to go back to a point I made earlier, it's sort of I think it's very much part and parcel of this notion to make the Constitution this impenetrable religious text, right? That like,
Yeah.
no, we're the ones who bestow meaning upon it. This is like the Latin Mass. There's no more vernacular. Um, I mean, funny I'm going with this metaphor when these justices are Catholic, and I'm pretty sure Alito is like mad about Vatican II, right? Like, um,
Yeah.
and
American,
yeah,
sorry.
go ahead.
The classic American Catholic thing of being really mad that there's a kind of a liberal pope, or
Right, right. Um,
reinventing Protestantism. Uh,
but no, this vision of the Constitution as an exclusive document for which what the public thinks does not matter is where I think some of this comes from. It's certainly what's behind, right, like the decision in Dobbs. You know, Part of I think the reason why that was that has been such a political earthquake is that people do have this like intuitive understanding, right, that the Constitution protects my ability to use my body as I choose. Um, and it had that understanding certainly since Roe, and I would say since before Roe. Um, and so suddenly losing it explicitly uh, unsettles people's sense of what the Constitution actually is and what it means.
yeah. We have a question from the chat from Lee. Um, I didn't read much criticism of the structure of the Supreme Court until conservatives took over it. Can you talk about the history of movements to fix these problems?
Sure. There's always been criticism of the structure of the Supreme Court. Like, during ratification, there are anti-federalist critics who are basically saying, you've created this thing that's entirely too powerful. And it's a real danger to people's liberties. Um, Part of what there have not been that many efforts across US history to really like change the court. And part it's because the court itself has shown what you could call humility, like a recognition that it is unlike the political branches. It has like no particular popular legitimacy. It has no particular way to enforce its rulings. Its power depends entirely on people willing to say, okay, sure. Um, uh, you know, when I think of efforts to push back on the court, it's often been in the context of courts that opponents of it believe have been captured by partisan opponents, right? So Jefferson, Marbury v. Madison comes into this whole thing where in like literally the last days of the Adams administration, Adams is like handing out judicial appointments. And the Federalist Senate is confirming them in this idea that we've created a bunch of new judgeships, we've added some seats to the Supreme Court, and we're going to fill these with co-partisans, and they'll act as a backstop against Jefferson's radical Jacobin agenda. Um, and Jefferson and his Republicans come into office, and they're like, "No, you can't do this." And so they shrink the size of the court. They revoke a bunch of these judicial appointments. They get rid of these seats, and then there's like a lawsuit. Like you can't do that. This is against the law. But Jefferson's response is sort of like the first instance of a president of an elected branch kind of saying, "You are overstepping your bounds. You don't have this authority, and so we're going to take it from you." Uh, During the Civil War, Republicans under Lincoln kind of expand the court to kind of secure their wartime policies. This is also where we see a bunch of new states created to get more Republicans in the Senate to secure their wartime policies. And then kind of the one that everyone knows, right, is Roosevelt trying to expand the court to secure the New Deal. Um, there's one theory about the court. One of the theories about the court is oftentimes the court represents kind of a redoubt of power for a political coalition that's on the decline. And so if we go to the New Deal example, the Lochner court is sort of like this is the court of the past 30 years of Republican governance, of kind of this old coalition of Eastern financial power, Western farmers, where it sort of represents their interests, and that's what they are trying to. And that court is representing their interests against the New Deal. And when you have a rising coalition and a court that represents declining one, you get all this conflict between the political branches and the court, and you get efforts to change it and to reform it and such. But there have not been that many attempts to really like change the court on a fundamental level. And I believe in the 1860s, there was an effort to create a supermajority requirement for the court's ability to overturn legislation, which is a thing Congress can do. It's like it's as far as I can tell, it's not unconstitutional because it would be structured to only affect the court's appellate jurisdiction or appellate jurisdiction. Um, and that didn't get off the ground, but that was one attempt. But there's not been a ton, um, and especially over the past 50 years, because there's been this sort of consensus about the court that it's like, oh, it defends our rights. It's sort of these people are unimpeachable, they're like experts, et cetera, et cetera. Um, there hasn't really been any appetite for it, but obviously that's changing, um, and my sense is that you know we're not far from like serious court reform being kind of like a litmus test for Democratic politicians, especially as we get generational changeover, right? Part of the issue politically is that like you just have a bunch of politicians who grew up in the old understanding of the court. You have a lot of legal scholars who grew up in the old understanding of the court. Like understandings of the court are currently deteriorating, and it's a moment to kind of like build up new ones.
Yeah, it's hard sledding, with a lot of these elderly uh leaders. We saw Biden with his commission of, you know, um the best minds in the land or whatever, and they basically punted, about what we're going to do about the court, and they just really couldn't muster up the energy. But yeah, I think as you say, it's going to become increasingly hard to deny. Um, one thing I think, maybe you mentioned Plessy versus Ferguson, right? And that being the decision that sort of blessed Jim Crow apartheid. Uh, I I think that's such a valuable um, observation to make, that it was, like it's a good opportunity to talk about how Jim Crow actually worked, I think,
Yeah.
in that, you know, very little of Jim Crow was like a big sign in the law saying that black people don't have any rights. They hid behind this facade of formal equality. And it was just, you rig the rules, you create these literacy tests, you have your grandfather clauses that don't explicitly say that, your grandfather has to be white. It just happens to be the case that before the Civil War, oh, black people could vote. But yeah, so can you get into this what this reveals about the structure of Jim Crow, and how this Thomas decision and the Alito decision to a lesser extent are sort of laying the groundwork, I think, for a possible, recreation of a system like that.
Yeah. So like in terms of like the actual, day-to-day operation of Jim Crow, the law is it's funny. You would have at these Jim Crow constitutional conventions at the turn of the 20th century, you would have like lawmakers say explicitly, we're doing this to keep black people out of politics. They would like say it out loud. But the actual text of the laws would what they would do is they would create a ton of discretion, right? They would say it is up to the registrar to determine whether or not someone passes a literacy test. So you have a literacy test. Grandfather clauses didn't, did not actually, those were too explicit. And um, uh, uh, when courts begin to address them, they're like, yeah, it's going a bit too far. But literacy tests, count the number of marbles in the jar, right? Like all this stuff. Uh, the whole point was you're giving a lot of discretion to the most local official. So you're devolving power down as much as possible. And you're basically saying, you know, whatever they decide is fine. And so they're if they decide to discriminate, that's fine. There's also, right, like the other piece of this is just like impunity for violence. But again, this is also kind of discretion, right? It's sort of law enforcement officers and state representatives saying, well, it happened, but we can't find any suspects, any culprits, so on and so forth. We're going to choose not to police in these areas, predominantly Black areas. Whatever happens there, we don't see it. The way this, and so the legal argument against Jim Crow, even early on, is that like, well, this is a violation of equal protection. Like we don't get the equal protection of the laws. And the constitutional theory here leans heavily on something called a state's police powers, not police in like in terms of law enforcement, but police in terms of the ability of the state to kind of like determine the basic structure of society within its borders, right? And in antebellum American law, states had expansive police powers. Basically, everything that wasn't explicitly enumerated in the Constitution that went to Congress was reserved to the states, and the states could basically do almost whatever they wanted, as long as it didn't kind of trip certain wires with regards to federal law and the Constitution, federal Constitution. And Jim Crow, you could so call constitutional theory, leaned really heavily on the idea that, like, yeah, the states have these broad and expansive police powers to regulate morals, to regulate conduct, to, you know, uh, uh, structure, the political system, and it's not the role of the federal government to stand in. It's basically the states under this theory of the case become not simply semi-sovereign, but like co-sovereigns with the national government. Um, and I think it's very clear that that's like the perspective of Clarence Thomas and Sam Alito and kind of like conservative legal movement. Some of this is for like explicitly kind of part. Like, I don't think Sam Alito has any particular commitment, right, to this. I think he's just like a Republican partisan and believes that this would benefit the Republican Party. Thomas seems to be much more ideological. Like this is the way things ought to be. This kind of system creates the space, right, for like domineering patriarchs to kind of like reign supreme, and that's Clarence Thomas's whole thing. But either way, the upshot is that it frees state legislatures to um, do essentially whatever they want to entrench sort of like favored political minorities into power in perpetuity, to impose standards of morality on the entire, public, whether that is, you can't have an abortion, you can't use contraception, in Thomas's vision, you have to, we don't have to go to church, but this is the official church of the state. Like Thomas, like the states have the right to establish churches. That falls under their police powers. Uh, uh, and under this theory, if you don't like it, you can just leave. You can go to another state, and thus the states become. There's no such thing. There's no longer any such thing as a unified, singular American citizenship. Or to put it another way, there's no like basic universal set of rights. One way you can think of the 14th Amendment is establishing, right? There's a universal set of basic rights that all Americans get, and subsequent 14th Amendment jurisprudence is like fleshing out what that is, right? So you can't be discriminated against on the basis of race or the basis of sex or the basis of gender. You have a right to privacy. Like all these things fall under this universal basic set of rights. The issue for reactionaries is that in the same way that universal basic income uh, 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 weakens the power of employers and bosses and owners of capital to coerce people. Because if you have some other source of income on which to depend, you can say no. The universal basic set of rights weakens the power of those at the top of received hierarchies to dominate others in the society because they can say no, and they have like a judicial remedy or a political remedy. And that's like the issue. And I think it's if you think of Jim Crow as basically sort of like the kind of world you can create when you no longer have a universal basis set of rights and you're devolving power all the way to the people at the top of these hierarchies and giving them broad discretion to use it, then I think you should understand the future that Alito and Thomas et al. Envision is not a literal recreation of Jim Crow, but a recreation of that sort of political and social dynamic, where if you're at the top of certain hierarchies, congratulations, you are free to do whatever you want. And if you are not, then you have to stay in your place. And if you manage to transcend your place, good for you. And don't you feel so much better about that because you knew the government didn't help you? Government didn't help you get ahead, and so that should give you, more psychic enjoyment. And if you couldn't get ahead, well, that's just because you really belonged where you fell in the first place.
Yeah. In our last couple minutes here, let's see. I just wanted to talk about the Alito flag controversy a little
Yeah.
bit. So briefly, Alito was found. He was photographed by his neighbors flying an upside down American flag, like a week after January 6th. He blamed it on his wife, like any good conservative, masculine alpha male. Um, and he also now, it turns out, over a period of months, it seems, was flying the Appeal to Heaven flag. I confess I did not even know what that was until I heard this story. But another flag flown at January 6th, basically referencing a plan to, turn the U.S. into explicitly theocratic. I don't know if I would call it Christian, but that's what they call themselves at least. Um, anyway, we already knew that Jenny Thomas, for instance, her brain is cooked on like conservative media. And now we see that Sam Alito and apparently his wife, if his word is to be trusted, is also, I mean, just fully marinated in the most disgusting slop of right wing media. And I wonder if you have any thoughts as to what it um, demonstrates about this facade of, as you said, this sort of legal priesthood, the guardian council of wise elders who are the only ones who could be trusted with the difficult task of saying whether the 15th Amendment guarantees a right to vote or not. You can't just read that. You got to trust them. And to realize that these guys are they're just normal Republican partisans. They're just exactly like all of the most deranged Facebook boomers. And, that's who rules the country for the moment, at least.
Yeah, no, I mean that's sort of what I would hope to be the thing that people take away from. I mean, in addition to the fact that Sam Alito is like basically, pro-insurrectionist, um, I want people to understand that these justices are not some special order of human being. Um, Despite the cult of personalities that exist around them, there's like we as we recall from last year's kind of Harlan Crow reporting from ProPublica, there's like an insane cult of personality around Clarence Thomas, and it's like he's just a guy. Um, and with this flag controversy, with it's I mean it really is kind of it's so perfectly deranged Facebook grandpa, right? Like I live here in Central Virginia, and although I live in like a liberal college town, if I drive 15 minutes outside the borders of the town, like I'm kind of basically in standard issue red rural America, and it's like yeah, I can drive by plenty of houses that are flying like "Let's Go Brandon" flags and like MAGA flags of various stripes. Like I'm sure that if I like took a nice like scenic drive through Nelson County, I could find at least one upside down American flag. And it's like, oh yeah, Sam Alito is just like one of those guys. He watches when he's not doing his job, and I'd be shocked if he does anything more than the bare minimum, right? Like I'm sure his clerks are doing all the work there. He's probably has Fox News on in the office all the time, and he listens to Charlie Kirk on the radio, right? He's just one of those guys. and Ben Shapiro, right? He's totally pilled. But I think it's important to recognize that no, they have no special dispensation, right? They're just people who happen to occupy powerful positions and are as affected by the same kind of dynamics with regards to media consumption, with regards to sort of like motivated reasoning as anyone else is. And so when they start to talk, as Alito has, about somehow being untouchable by our mere mortals in the elected branches, the proper response is to be like, yo, fuck off, you know, like what are you talking about? Um, uh,
Yeah.
uh, and the same goes for Clarence Thomas. I mean, it's funny, some of the conservatives on the court seem to recognize this. Like, it's clear that John Roberts understands. I mean, John Roberts is terrible, but he seems to understand the political reality of his position and how much his project as a Chief Justice depends on maintaining the fiction that they're all somehow impartial. Amy Coney Barrett certainly recognizes this. Brett Kavanaugh, I think, has an inkling of it to the extent that he can like grasp complicated ideas. Um, but Thomas, Alito, Gorsuch seem completely indifferent, if not blind, to this reality. But I think it's useful for the rest of us to see it, in part because it can help build political, support for court reform. And court reform doesn't just have to mean expanding the court, which, as much as I think that would be well taken, that's just going to be supremely difficult. It's like the highest possible bar. It runs so counter to people's understandings, even people who are not sympathetic to the court, that like it's a real challenge. But um, uh, strong ethics rules, changing their funding, right? Like changing, new rules about which cases they have to take, how, rules about sort of like how expansive they can go in their ruling, like, oh, that's totally on the table and worth pursuing. But I think kind of the first step towards pursuing it is just reminding the public that like these aren't demigods. They're just like Clarence Thomas was a Republican apparatchik, right? He was like some hack in the Reagan administration who got promoted very quickly because he was like the dark-skinned black guy from a poor upbringing who was also like a Reaganite Republican hack. That's it. He was given the office of the Equal Employment Opportunity Commission, not because he had any particular expertise in employment law, because like they thought it'd be, a good bit to give that to like a conservative black guy.
Yeah.
um,
Uh,
Sam Alito likewise is just a a partisan Republican judge. Brett Kavanaugh, literally just a partisan hack, right? Sort of like a guy who helped Bush try to steal the election in Florida. So it's sort of like these these people didn't come down from like, you know, Mount Olympus, Mount Rushmore, bearing their knowledge um, of the Constitution. They are political actors. Some of them are better than others at concealing it, but that's what they are. And the same goes for the liberal justices too. They're political actors too. Um, these
yeah.
are all political actors, and we have to understand the court as a political institution. And at the very least, like challenge this idea that it has like this exclusive ability to say what the Constitution means. Nonsense.
Yeah. I've thought before that I would not be a great, you know, local judge or a district judge, but I'd be a great Supreme Court justice. Super easy gig. You just determine your political outcome, get the clerks to write it for you. Boom, on the golf course by 3 p.m. at the latest. Um,
But
let
I'll say real quick. I'll say real quick. I think that there is a real job there, right? It is the case that like there are things that come up that don't have an easy answer, not because the Constitution is so complicated, but because the Constitution doesn't speak to it, right? What does the Constitution actually say about affirmative action? Nothing. It doesn't say anything about affirmative action. You can't derive from first principles reading the Constitution what you should do about affirmative action. And so that does require you, like, I think we do need people in these sorts of positions, and they do have a job to do. And I think the folly is thinking that you can just sort of like read the Constitution and come to an easy answer. You can say, well, with the original public meaning and blah blah blah. No, you can't. You actually have to judge. That's like a real judge. You have to judge. And although he's not particularly popular, there's no cult of personality around him. He's sort of a dweeb, and he says and does things I disagree with. I actually kind of admire Stephen Breyer, the former justice, for exactly this reason. Stephen Breyer seemed to understand correctly that his job was to judge, and you can't judge by just applying a method. You actually have to like pull in everything about the situation, the facts of the case, the findings of the previous court, what the Constitution says, what the law says, what the lawmakers say. You have to think, what are the compelling interests at stake? And you have to come to some sort of conclusion that isn't going to satisfy everyone, but that maybe provides the best outcome for as many people as possible. Um,
Yeah.
uh, that kind of approach requires a little humility about your role. And that's what's like on short supply, not just on the Supreme Court, but I think like throughout the federal judiciary.
Yeah. We're almost out of time here, so just a quick prediction or request. Any prediction, sorry, question from Joel. Any prediction on whether the coming Rahimi opinion will dial back the history and tradition part of Brune, yielding some wild lower court decisions about what regulations can't stand?
I hope so. There's been a lot of great writing um, about the fact that is it Bruin? I've always been pronouncing it Bruin. Bruin,
Probably.
Bruin is just creates a completely absurd and unworkable standard for adjudicating gun regulations. Like it's just like it's impossible. And in this case, right, in this case, it's sort of like the implication of Bruin is that states can't pass laws forbidding people convicted of domestic violence from owning firearms because, hey, it didn't exist in the 19th century because it was legal to beat your wife in the 19th century. And it's like that's an absurd conclusion that rightfully offends our intuitions. And it's like a standard that says that you can't prevent an abuser from owning a gun. It's like a standard that shouldn't exist, like straightforwardly. And so I hope that Rahimi ends up, if not just completely undermining Bruin, then like paring it back dramatically. We'll see what happens. And I'll say just because this cult of Clarence Thomas and this sort of like great far-seeing justice. That Bruin opinion is like should be just like Heller should be number one on Scalia as a dumbass. Bruin should be number one on Clarence Thomas is not that smart because like the whole thing hangs on a really elementary logical error, which is that because legislatures in the 19th century didn't say X, therefore they didn't believe they had the power to do X. But that doesn't follow whatsoever, right? Like you
No.
can believe that you can do A or X and never express that because it never comes up. Um, but like Bruin rests on this idea. No, the courts, I mean, the legislatures didn't pass these sorts of laws, so they didn't have the power to. What? Doesn't
Yeah.
make any sense. Like anyone in like a 100 level like formal logic class will like pick that up immediately. Not Clarence Thomas.
It's also fake. Last thing I'll say, before we sign off, because we are out of time, is that it's also just false. James Madison himself, the guy who wrote the Second Amendment, proposed two very strict gun control laws for the Virginia legislature. They said you're not allowed to carry personal firearms outside of your own property, and that's pretty strict. They didn't
Yeah.
pass, but it does show that he thought that was a thing that the legislatures could do. Anyway, originalism. I love it. Um, Jamelle Bouie, thanks for coming on. Thanks everyone for watching, and we'll see you next week.
Yeah. Thanks for having me.